Let's just jump right into this. Welcome to today's Explainer, where we're looking at a 40-year legal mystery that basically started with a simple copy and paste error. We're talking about the Quixotic drift of a legal concept. Sounds kind of poetic, right? But what it really means is how translating a law from one country to another can cause massive, unexpected chaos in the real world.
So the whole thing boils down to this one riddle. Imagine a factory pollutes a river on Monday, stops polluting on Tuesday, but still hasn't fixed its broken pipes by Wednesday. So, which days does it actually get fined? Monday? Monday through Wednesday? Just Wednesday? Well, for decades, this exact question literally crippled Taiwan's environmental enforcement. Nobody, not even the top legal scholars, could agree on the answer.
You see, laws don't just perfectly translate across borders. In fact, they often crash, kind of like incompatible software. We usually assume a good law just works anywhere, right? You copy a pollution law from America, paste it into Taiwan, and boom, clean air and water. But as we'll see today, importing foreign legal concepts without having the right operating system to run them, it causes massive system glitches.
So, moving into Section 1, the magical drift of legal concepts, we're going to look at how a single phrase drifted across the ocean and completely mutated.
To really get this, we got to look at Taiwan's 1974 Legislative Yuan debate. They were trying to pass the Waste Disposal Act, and one official essentially just says, hey, reference the U.S. pollution control law. Nixon asked Congress to fine factories $10,000 a day until they improve. And just like that, this monumental Nixon-era American legal weapon was casually dropped right into Taiwanese law. No real adaptation, just dropped in.
On to Section 2, transplanting America's anti-pollution weapon, where the per-day continuous penalty enters Taiwan. You see, back in the 1970s, Taiwan was industrializing super fast, and they desperately needed a quick fix for pollution. So they transplanted this American weapon to create the per-day continuous penalty. The goal? Super simple. Bleed polluters dry financially until they actually clean up their act.
Now, the U.S. per-day civil penalty is incredibly flexible. It's basically a legal Swiss Army knife. It doesn't care about strict academic categories or boxes. Its entire purpose is to simultaneously punish the factory for past violations, strip away any economic gains they made by polluting, and coerce them into fixing the problem right now. It's a blunt, but a highly effective tool.
But here's where the plot thickens. Section 3, encountering German legal grammar conflict. This is essentially about installing an American app on a German operating system. Historically, Taiwan's administrative law ran on a very strict, rule-based German legal grammar. So they were trying to take that American Swiss Army knife and force it into a strictly defined German toolkit. You can probably guess how well that went.
The software incompatibility is just stark. The American civil penalty is a flexible tool that blends punishment and coercion all at once, giving courts a ton of flexibility. But the German framework, it demands strictly separated tools. It insists you absolutely must choose one single legal purpose, with very low flexibility and super strict legal boundaries.
Let's break down that German system. First, you have the Geldbuße, which basically translates to an administrative fine. This concept is focused strictly on punishing a past wrongful action based on proven culpability. It only looks backwards. Did you actively dump toxic waste today? Yes? Okay. Then you get punished for today. End of story.
On the total opposite side of the German system, you have the Zwangsgeld, or coercive fine. This one focuses strictly on forcing future compliance. It doesn't punish the past at all. It just puts a financial squeeze on the factory until they finally fix that broken pipe. And the second the pipe is fixed, the pressure stops completely.
So what happens when you cram an American Swiss Army knife into these strict German boxes? Total chaos. Because Taiwan forced the American tool into these definitions, legal scholars actually broke into camps, violently disagreeing on what a per-day fine really meant. The administrative sanction view argued that every single day requires proof of a brand new, active pollution event to issue a fine. Meanwhile, the coercive fine view argued, no, the fine is just financial pressure to fix the pipe, so you don't need new proof of pollution each day.
That leads us right into Section 4, Taiwan's 20-year legal debate, covering the chaos of classifying an amorphous concept. This fundamental disagreement sparked a 2-decade argument that practically paralyzed inspectors on the ground.
We ended up with 3 distinct theoretical camps. The penalty camp insisted on daily proof of new violations. The coercion camp viewed the fines as mere pressure to finish repairs. And then the dual nature camp tried to play peacemaker, saying it acts as a penalty on days with actual emissions and coercion on non-emission days. I mean, can you imagine being a frontline inspector trying to write a ticket while lawyers sit around arguing over three wildly different interpretations of the exact same law?
Which really begs the question, right? If the legal system can't even agree on what the fine is supposed to do, how can it effectively stop environmental destruction? It poses a massive real-world problem when abstract legal theory totally breaks down the practical enforcement of environmental justice. Factories were just exploiting this confusion, tying up fines in court for years while the pollution kept right on flowing.
Thankfully, we hit a turning point in Section 5, the 2015 per occurrence domestication, or taming the foreign transplant. This is where Taiwan decides to finally stop arguing over translation and starts actually localizing the law to make it work for their specific system. Tracing this on a timeline, it literally took 4 decades. We go from the initial transplant of the American per day law back in 1974 to a constitutional interpretation in 2005 that tried to clarify the boundaries, and finally to 2015 where the per occurrence amendment officially rewrote the law. 40 years to finally domesticate this immigrant legal concept.
Here's how they fixed it. Under the old per-day system, the stroke of midnight automatically triggered a new fine without any new investigation. But under the new per-occurrence system, inspectors have to conduct a fresh investigation and gather new proof before issuing the next fine. By changing per day to per occurrence, they sacrificed that automatic daily pressure, sure, but they gained massive legal clarity by requiring an actual documented investigation every single time.
Now, we've tamed the law, but we've got one more stop. Section 6, the future of sanction and execution, where we look at untangling the final legal knots. Our explainer wouldn't be complete without looking at the underlying hardware issue we still have to fix.
Because while that 2015 fix stopped the automatic midnight fines, it still kind of blurred the lines between punishing past pollution and forcing future pipe repairs. The crucial point here is that we still haven't perfectly separated the act of punishing the factory for Monday's toxic spill from the act of forcing them to buy a new pipe on Wednesday. To solve this, the source material proposes this beautifully structured, dual-track solution. Track 1 is for administrative fines, basically, punish mathematically proven past pollution violations with proportional fines. Track 2 is for execution or coercive fines. Use dedicated coercive tools solely to force future equipment repairs. It keeps the punishment track and the coercion track completely separate and legally distinct. A much cleaner operating system, right?
Interestingly, we can actually look to our neighbors for inspiration here, specifically Japan's post-war experience. Japan also has a mixed legal heritage, but they didn't just blindly copy the strict German model. Instead, they retreated from general coercive fine systems, actively recombined foreign concepts into localized frameworks, and tailored their execution methods to specific individual laws. Japan's experience really shows us that a mixed legal heritage doesn't mean you have to strictly choose between America or Germany. You can absolutely curate your own localized solutions.
So I want to leave you with this thought to ponder as we wrap up our explainer into this fascinating, quixotic drift of legal translation. Will our legal systems ever truly speak a universal language, or will the pursuit of justice always require translating the grammar of power? The words we use in our laws absolutely matter, but how we adapt them to our own realities matters even more. Thank you so much for joining me today. Keep questioning, keep learning, and I'll see you in the next one.